Good morning, ladies and gentlemen. The webinar will start in approximately 1 minute while we wait for others to join. Good morning for those who are joining from Europe, and good afternoon for those joining from Asia Pacific. Wherever you are in the world, I hope that you and your families and loved ones are all safe and well. Welcome to this webinar on the data privacy and security considerations for global employers to consider as they return their employees to the workplace and establish and expand the remote working capabilities as business enters the new normal. This session will focus on companies operating in Asia Pacific. We are delighted to be joined by a number of partners from Baker McKenzie. Next slide, please. The scale of disruption from the COVID-19 pandemic is unprecedented and presents significant challenges as business starts to reverse the lockdowns required to contain and manage the spread of the virus. We are delighted that Baker McKenzie has agreed to offer this series of webinars providing information on the key privacy and security developments, challenges and opportunities for you to consider. Since mid-March, WBCSD has stepped up the challenge to address this crisis and support businesses by sharing information, knowledge and insights from across our membership. And we're incredibly grateful for the fantastic support we've received from Baker McKenzie in being able to do that. Principally, we have established 3 new projects to support our members and business more broadly to navigate the crisis. These address vital supply chains with a focus on supply chain resilience, beginning with food system security, long-term impacts, which seek to understand the vulnerabilities revealed by the crisis and the lessons for future resilience and the shift towards stakeholder capitalism. And third, the return to the new normal scenarios, where this series of webinars fit in, as we focus on privacy issues that businesses are facing. In addition, WBCSD is holding a series of virtual events that address some of our existing projects and work streams, as well as our COVID response work. Next slide, please. We are proud to highlight actions from our member companies and other businesses who are taking extraordinary actions as the world learns to deal with this crisis. These actions demonstrate how business leadership is supporting people, communities, and economies around the world. By doing what business does best, and that's responding fast. You can find additional information on institutional partnerships, key media articles, policy updates, and examples of whether business is walking the talk on stakeholder capitalism. And our website address is there at the bottom of the page. Finally, some housekeeping details. Just to let everyone know, this session is being recorded. All participants have been placed on mute and are in listen-only mode. And we do that because we have so many participants on these webinars that it's not really manageable if we let everyone try and speak. But we do encourage you to ask questions. So to ask a question, please use the Q&A button at the bottom of the screen. So you'll see at the bottom of the screen, two bubbles there with Q&A. If you just click on that, we will leave time at the end of the webinar to address questions, but feel free to send them through throughout the presentation. And we really encourage you to please send the questions as early as possible, because that helps us in terms of collating the questions and putting those to the speakers. Lastly, like most of you, we are all presenting from our homes. While we've all attempted to create a studio-like atmosphere, please forgive the occasional dog bark or doorbell or other noise. We're all doing our best in this new environment. And now I'd like to turn over to Anne from Baker McKenzie, who will lead you through the presentation. Thank you, Anne.
Great, thank you very much, Mario, and thank you for having us today. So hello everyone, my name's Anne Pettit and I'm from Sydney, and I'm joined here today by my colleague Ken Takase from Tokyo, Joe Fanyu from Taipei, and Sarana Rivatana from Bangkok. So during this 1 hour session, we're going to discuss data privacy and some broader data protection considerations across APAC as businesses look to reopen the workplace. Now, we're looking at these issues sort of, across the region. But one really important point to note up front is there are differences between APAC jurisdictions in how local laws are regulating these issues. So we're going to look to give you a flavour of some of the differences, but we're not going to be doing a country by country dance. We do have some reference materials at the end of the presentation which do go into more detail per jurisdiction, which might answer some further questions for you. So let me kick us off with an overview of the agenda. And so the issues we're going to discuss include, firstly, we're going to look at privacy issues that we're seeing with this sort of new data collection we're seeing at workplaces of predominantly health information, temperature scanning, health questionnaires and the like. Now, as Mario said, most of us are still working from home and we're not all about to go back to the office tomorrow. So we did want to spend some time on our second topic looking at some of the security issues that have been talked about with these remote working, teleworking arrangements. And in that context too, we wanted to then go on to talk about what are some of the privacy issues with the sometimes sensitive topic of wanting to monitor workforces remotely. And then again, in that same context, we're seeing as part of the remote working arrangements, more remote services being provided by vendors, and that of course also raises security concerns. So we wanted to spend some time on that as well. And then finally, for our last topic, we're going to look beyond the workplace and look at some of the data privacy issues and security risks that are arising with some of the rapidly changing business models that we're seeing emerging as workplaces try to keep operating in this new world. Now, of course, issues around reopening of the workplace, that they can't be looked at through a privacy lens alone. So employment laws, workplace safety laws, for example, they also need to be considered. So in this session, we've just got a focus on data protection issues, but we're going to touch on some of the workplace employment, health and safety issues as well. You might also, if you need some more information on those topics, you might want to listen to the WBCSD employment session that our APAC employment colleagues recently did. So let me move to the next slide, please, and we'll get starting with our first topic. So this first topic, we wanted to do a bit of a deep dive into some of the questions that certainly I'm seeing, a colleague Ken's seeing on as businesses want to do enhanced health screening of their employees. And we know that many employers are looking to implement additional health screening at their workplaces. Look, it's as part often as reopening of the workplace measures. So in many cases, this might be because the employer wants to meet their own workplace health and safety obligations. They might be mandated to do certain checks. And these checks might involve, for example, just checking a temperature, might be asking questions about a person's health in particular, do they exhibit any of the symptoms of COVID-19? Checks might go a bit further, asking for questions about recent travel. And in some cases, the checks are going to involve collection of health information, and that might attract special protections under privacy laws, and so extra care might need to be taken. So Ken, with that background, what sort of issues should an employer who's looking to implement these sorts of health screening measures consider?
Sure, thanks, Anne. So I think it's important for an employer first to take a big step back and be clear as to what the purposes of the health screening are. If there are legal requirements by local governments or authorities to provide such information, then most jurisdictions, there will be exemptions to the privacy laws to allow that form of collection and provision. But if it's not necessarily a strict legal requirement, then employers will need to be a lot more careful, arguing that there are, the health screening required for health and safety purposes alone. That may not be sufficient. It will be important for employers to both document and also demonstrate that the testing is part of a broader workplace health and safety strategy. And the broader strategy may also include other measures such as social distancing within the office. And I'm sure it's the same with many of the listeners here today. But the Baker McKenzie Tokyo office has recently reopened as of yesterday. And as part of our broader health and safety strategy, we've also got requirements for people who are visiting the office to wear masks, to use hand sanitizers. There's still a ban on sort of internal meetings. So if you want to have an internal meeting, you have to do that by Zoom or some other method. And we've also split our offices into teams A, B, and C. So A will go on Monday, and B will go on Tuesday, and C will go on Wednesday, and so forth. So those sorts of other methods should also be included within the grander scheme of things. So having just the temperature checks alone in isolation may put companies at sort of a higher risk. So things need to be careful there. With regards to documenting, which I've mentioned, one of the most important documents that will be required would be having a look at the company's privacy policy. Now, most companies, of course, will already have their existing privacy policies. So as a first step, it will be to review those privacy policies and have a look at what their scope is. Now, it's highly unlikely that there'll be any provisions specifically dealing with health screenings. So those will need to be addressed either by updating the privacy policy or by supplementing it using some other method. The other thing that companies will need to do, and you've touched upon this already, is assess whether the information may be sensitive personal information. Most health data will be treated as sensitive personal data, and most jurisdictions and their rules become a lot stricter there. With regard to temperature checks, there's a question as to whether a person's temperature in isolation will be sensitive personal data. I guess it can tie to a person's health in certain circumstances, but people's temperatures go up and down depending upon the day, depending upon the time. So in that sense, maybe in isolation they may not be treated as personal information or sensitive personal information. So that will be an assessment that needs to be taken out on a country by country basis.
I think that to me is a really good point. I know sort of when we've been looking at some of these issues for Australia, we might be looking at the scenario where the question is there actually a collection in the first place of someone's temperature, or are you just using, say, a temperature gun that just checks the temperature but perhaps doesn't collect any data? And it has been quite important to understand how these devices work and what actually do they collect, and is it a collection within the bounds of the particular privacy law that's regulated? I think too, one of the other big issues that we see around this, and we're often asked, is do you have to get employee consent to do these checks in the first place, Ken?
Sure, no, that's a very good point. And employee consent, whether it's required or not, again, will depend upon the jurisdiction that you're in and also the type of screening that you're trying to conduct. It'll probably be necessary in most countries where you're trying to gather information about travel information, where their employee has been. But one thing to note about employee consent, and this will again differ depending on the jurisdiction, is that in itself may not be recognized in certain jurisdictions. And what I mean by that is that in some jurisdictions, they say that the employer-employee relationship is not a balanced relationship. The employer is in a stronger position than the employee, so that an employee may never actually be in a position where they can freely give their consent. So in those sorts of jurisdictions, you need to figure out other ways of trying to gather that information if you require it. But fortunately for most jurisdictions, they will allow you to obtain employee consent. And then you need to think about the scenario, what would you do if an employee decides not to give consent? And it's best to do that sort of analysis before you embark upon collecting information or gathering that sort of information.
So, you talk about conducting an analysis. I'm not sure if all the audience will be familiar with data privacy impact assessments, but this seems to me sort of an area where, particularly if you're doing something that is not business as usual for the workplace, it's the kind of thing you might want to do an impact assessment for. So could you just talk a little bit about those?
Sure. So data privacy impact assessments or data impact assessments are essentially tools that companies can use to determine whether or not a particular data processing activity is going to be high risk or not. So it's typically the situation where you probably want to do one before embarking upon a new program or launching a new product which will touch upon personal data. So particularly for the types of scenarios that we're talking about now, where you're doing checks of employees that may touch upon sensitive personal data, doing a data protection impact assessment or an impact assessment is certainly a good idea. Now, in many jurisdictions, if there's been a breach some sort of issue with regard to privacy in the data protection authority, when they step in, the first thing that they're going to ask the company to do is to provide their data impact assessment and have a look at that to see what sorts of assessments were done, why the company decided to press ahead, and what sorts of security considerations, etc., they took into consideration when putting that data protection impact assessment together. And not being able to provide that immediately may incur punishments such as fines.
I guess to, sorry Ken, I guess to doing a privacy impact assessment should pick up the whole life cycle of the handling of the data, including retention, and we haven't yet talked about retention issues here.
Sure, and retention is a really good point. And I think we don't hear enough companies talking about retention. So you're gathering this information. The information won't need to be stored or held by the company forever. There will come a point in time where that information will need to be addressed and either destroyed or retained for a further defined period. But certainly, yeah, that sort of assessment should be taken into consideration at the data impact assessment phase as well. In any event, these impact assessments are good for companies. I recommend that companies do them as frequently as they can, just so that the companies can, again, take that big step back and actually figure out what their overall objectives are. So we've talked about measures such as temperature testing. We've talked about surveys with regard to travel of employees, where they've gone, things like that. But going forward, one of the things that may become a possibility for companies to consider is COVID-19 testing. Now that will enter kind of like a sort of a more scary phase or dangerous phase for companies. And why I say this is because these tests are probably going to become cheaper, faster, hopefully less invasive, and there might be more companies out there who actually want to start exploring whether they should test employees. And at the data impact assessment phase, I think it will be a good idea to think, well, what are you trying to achieve by conducting such tests? Is it to give certain employees an immunity pass? They've already contracted it. They're clearly not showing symptoms anymore. Is that what is being tried to achieve? But science behind immunity passes, or what is immunity relating to COVID-19 is extremely uncertain. So at this point in time, it sounds like a bad idea to think about embarking
Certainly, and maybe just one more question on this topic, and then we'll move on to the next topic. But we've been talking about doing the test, but of course, well, what if a test is positive? For an employer, what are the sorts of information they can disclose about the infected employee, or maybe the more important question is, what are the sorts of information they cannot disclose about the infected employee to other workers, and thinking through those issues as part of their privacy assessment.
Yeah, precisely. And which other employees, which other workers do you disclose it to, and what sort of manner do you disclose it to them? Do you actually identify that particular individual? Maybe that's necessary if it's someone who's in close contact with that individual, but in general terms, perhaps it's not necessary if you just need to mention that it's a particular person on a particular floor or a particular department. Maybe that alone might be sufficient.
Great, thanks, Ken. We might now move on to the second topic. So we have the next slide, please. So we're shifting gears a bit now. We're working from home. We're probably going to be working from home, a lot of us, for some time, although I'm pleased to hear that our Tokyo office is now back and open. But I think most people will have seen reports about increased security risks with people working remotely, and not just in a privacy sense, but putting corporate information at risk, putting customer information at risk. And so can you just talk a little bit about what are some of the data security risks that have been talked about with working from home and remote working arrangements?
I think there's a lot of potential risks out there with employees taking their computers home or operating them in public spaces. Often people are stuck at home with others. Those others may be family members. They may not be family members. Even if they are family members, sometimes family members may be working for competitors. So just having your laptop at home in itself can sometimes be a security risk. But we've also seen sort of more attempts by hackers and also by various malware type companies sort of ramping up their activities right now because a lot of companies are in sort of remote environments and therefore trying to take advantage. Ransomware attacks, I think, are a lot more common these days, and we seem to be asked increasingly to assist clients with those sorts of issues. But then again, I think, what's the question? The question is, what do you do to address those sorts of security issues? And I think the first thing that companies need to do is make sure that their employees are properly educated and trained up on the company's security systems, make sure that the training programs are up to date, and that the employees have actually sat those and passed those, and that there's records to record the people who've done those, and making sure that people who haven't done them do them as quickly as possible.
I think with this context too, like many, people talk about these new security risks, but in many respects, they're not new. It's just the scale of things. We've got so many more people working from home. But I mean, another important thing to check is, well, do our contractual agreements with our customers enable us to do the working from home arrangements, or does that expose people from breach? But I guess you've probably got a few other thoughts to share on some of the things for businesses to do.
Yeah, no, that's a very good point with regard to the contractual arrangements. And it's a tricky one as well. If the customer arrangements say that their information cannot be taken off premises, then you need to address that and sort of find a way around that as well. I totally agree that these aren't new arrangements. We've had work from home before, but just not at this particular scale. And I guess not using the technologies that we're using, such as Zoom, what we're using right now, to the scale that we've used it in the past. And we've heard about issues with people Zoom crashing and things like that. But there are ways, of course, to deal with that. Both, within Zoom, there's paid-for versions of Zoom which has increased security using passcodes and passwords for setting up Zoom. And I think now that's sort of like one of the default functions. But there's also other methods that companies can take into consideration to try and reduce risks. For example, using more cloud-based services that can perhaps increase security as well, rather than having software and things on a person's computer. If you can have that software in the cloud, then the organization can control security and safety in that sort of virtual environment a lot easier than they can if the software is on a person's PC, for example.
Thanks. And I guess one question that comes to mind, we've seen with a lot of issues that regulators have relaxed requirements, across a broad range of things to allow business to continue in the midst of the pandemic. But what about data breaches? What's your take on whether a privacy regulator is going to be forgiving if there is a security breach coming out of a working from home arrangement?
I don't necessarily think they're going to be any more forgiving than they will be in regular circumstances. I think that they certainly have their attention more focused on guiding companies as to what to do in this sort of environment, rather than taking sort of action, against companies. Certainly where there are uncertainties because of this COVID-19 situation and privacy laws, then I expect there will be more leniency in those sorts of respects. But if there's pure sort of data breach, which affects, lots of employee data or customer data, then I expect that eventually the regulators will start looking into those and taking actions.
Great, thanks, Kenya. It's a good point on the uncertainty. I often think, if we're uncertain on an issue, it's very likely the regulator might be as well, but it's about navigating it. So thank you for that. We might move on now to our third topic. So our third topic is about remote workforce monitoring. Now, employer monitoring of workforces, it's happened for a long time and it can be a sensitive issue. But of course, if you're looking to do workforce monitoring and you're in a remote working environment, it can become a bit more challenging. So Joanne, I'm going to come to you now. Do you mind just giving us an overview of why workforce monitoring might be important to employers in the first place, and then some of the sensitivities involved in this space, please?
Yes, thank you. And so, yes, we do see, there's a trend. There will be more and more employees working from home. And we also see like the Facebook or Twitter, they announced they will allow, more employees working from home. So, but we also see companies starting to express more and more concerns about working from home. And the top concerns include like the productivities, like the company started to worry about if the employees will be the same productivities as when they working in the office. The other concern is the confidentiality of company information. Companies will worry about how the employees will treat, the confidential nature of the company information. How do they leak the trade secret or confidential information to third parties or even competitors, when they're at home. And of course, the third concern, top concern, is the security. So other concerns also include like the employees will behave properly when they work at home without any monitoring from the company, and does the employees, when they work from home, they create a potential liability to the company's clients or increase more risk. So companies start to have these more and more concerns. But in general, when the employees start to try to control, monitor, but the employees' privacy is also considered really sensitive issues, especially in the court. So we expect that these issues will become more challenging for companies, because the remote working can make employees monitoring more difficult and more challenging. And I think it will become a really difficult issue for the companies.
Thanks, Joanne. And is one of the things that you think about in this space, your mind goes to, is issues around bring your own devices. Lots of companies might not issue phones and laptops and other devices to all their employees, or people in finding workarounds and needing to work at home might be using their own personal devices more for work than before. But as employees might be using their own devices for work, when it actually comes to bring your own devices monitoring scenarios like you've been talking about, what sorts of things should be considered by employers?
Yes, bring your own device, I think it's not the really new topic, not only after the virus. So I believe most companies already have these policy in place before the COVID-19, but it would still suggest, the company to revisit the policy to ensure all the scenarios are covered. For instance, before, maybe most companies, although they allow the personal device to be used for the work, but still, mainly rely on the company device. But the company device before the COVID-19, many were used in the office. But after COVID-19, when the employees start to work more at home, so we will see the company device might be more likely to be used outside the office at home. So the company should start to think about if the policy, do they have the good policy for the company device used outside the office. In addition to this, because the employees start to work at home, so we also know that employees, they have a maybe different personal device. Some device they have registered with the company so they can use for the work. But when they start to work at home, they might also try to use the unregistered device that is used for the work, to access the work file, to access to the company's networks. So I think this is also important for the company start to think about, to revisit its previous policy to see if all these scenarios covered. So the second advice is that, so the company might also want to ensure that the current bring your own device have really provide the safe protection for the company. As we mentioned that there will be new device and more device to be used outside the company. And there might be more and more employees. So before, maybe there's only limited number of employees working in the office, but now we can see more and more, not only the employees, but also maybe the temporary workers and also contractors. They might also use the personal device to access the company document. And we also see the employees might have more and more flexibility for their working location. So they might work at home or in the restaurant, in a cafe, or outdoor, or even in different jurisdictions. So that's why maybe there's new data to be collected. So such as like a GPS or geolocation data will be collected. So this will be important for the company to revisit all their relevant policy to ensure that all is covered for its future work from home policy. So in general, in APAC jurisdiction, the update of bring your own device policy or relevant policy, consent might not be required. But the best practice usually is you still need to send a notice to have the communication with the employees. But if these bring your own device is included in the employment agreement, then the consent, another agreement should be obtained from the employees.
So I'm conscious, Joanne, there's a few other things that we wanted to talk about on this topic. So I might just stop you there on bring your own devices. I did want to talk about contact tracing apps a bit and other apps that workplaces might be using to monitor employees. And when we were preparing for this session, the speakers, we were discussing amongst ourselves the different approaches that various governments and businesses have been taking about the use of contact tracing apps. So it has been a very hot issue where I'm in Australia. There's actually a government issued contact tracing app that you can use, but it is actually illegal under privacy laws and other laws for an employer or anyone to make use of this contact tracing app mandatory. But the law is quite different on that issue in other jurisdictions. There's also other monitoring apps that companies might want their employees to use. So Joanne, can you just share a few more thoughts about installing apps, whether it's on BYO devices issued by the company or on BYO devices or actually on devices issued by the company that would be doing some monitoring of the workforce? Thanks.
Sure. Yes, it's a good question. Indeed, this issue is really complicated. So when we talk about the contact tracing app, actually we have different type of contact tracing app which operate differently and also collect different data. For instance, maybe app developed by the government or by the private developer, or app developed for the infected employees or for all the employees, and what kind of data will be collected by the app, subject to different purpose, maybe the non-personal data, the personal data, or even the sensitive data. And who collect the data? Sometimes it's the government, sometimes the company, or sometimes it's just safe in the phone. So all make this issue really complicated. So the other reason is for why it's so complicated is because the law does not really have really clear guidance on that. So although we can see started to like some jurisdiction like Hong Kong start to have the guidance to issue the guidance to clarify some privacy issues. So we understand that for some companies, they want to install, these apps so that they can protect the safety of the work environment, which is also one of their obligations under the law. But from the privacy and data protection perspective, we do see these installation or encourage employees to install this app carries quite high risk. So we suggest the company, when they consider to use the contact tracing app, first maybe to determine, the purpose of use this contact tracing app, to also to have detailed information about how the app they choose how they will operate or what kind of data will be collected. And if the purpose or to use this app is to comply with the government request. So we do see, like in China, in some places, the government requests company to report this information to them. So in this scenario, maybe the company will have a good argument that it is okay, not to get the consent. But still, we request we suggest to company to carefully communicate with the employee, to send a notice and also carefully collect and also process. But if there's a no law request, the company to install, we think still, the consent is the best way to do it.
Thanks, Jo-Fan. We will probably just need to move on there, just in the interest of getting through all the topics. It is quite a complex area because, of course, in addition to maybe considering privacy laws, you might also have to consider general surveillance laws, even specific workplace surveillance laws, as well as some government mandated requirements, as Jo-Fan mentioned. But perhaps we can pick it up a bit more in the Q&A session, because I know a couple of people have asked some questions. So let me move now on to our fourth topic. So we're going to focus now on vendors providing remote servicing. Now, vendors providing remote servicing, it's not a new issue, obviously. But one impact of COVID-19 is likely to be that we'll be letting vendors into our workplaces increasingly on a remote basis. And so that of itself raises some security issues. So let me bring our last speaker into the conversation now. So Sarana, could you list out for us some of the risks in allowing remote servicing by vendors?
Thank you, Anne. As Anne mentioned, there's been increasingly implementation of virtual network and also the implementation of remote working. Organizations, companies have used various online channels for communications internally and of course to communicate with the customers. So there have been an increasingly use of the third-party services and also networks, such as software as service networks, web hosting and stuff, emails or other communications channels. So this has been the case where the company has increasingly disclosed their data to third party and also maybe share among the company themselves digitally with their customers, and also sharing with the third party service providers or the vendors. And also because of the remote working implementation within the organization, there has also been an increase or more of the endpoints where all the employees have been now working at home, working from home. And also the third-party vendors themselves, they might have also implemented this remote working policy as well. So both internally and externally, there have been an increase of the endpoints where it could expand the surface for the cybersecurity risk. And because third party can also access to the company system and the networks, so it could be susceptible or more susceptible to cyber threats such as like hacking or farming or spreading malware to the
And maybe I could
organizations.
just interrupt you there, Sarana. So maybe we could just move on to talking about, some of the important risk mitigations, and maybe if you could just spend 1 minute on that, and then hand over to Joe Fan for some quick comments as well.
So, so from a threat that has been increased, the company has to come and to firstly, to conduct internal due diligence, like what kind of services that the company has been outsourced to third party, and also what which vendors or what companies that the organization have been using. And then next step is to do probably data protection impact assessment. This is the objective to know what type of data that you share and how much you've shared or disclosed data outside the company, and to assess the risk level. And then third step is to conduct the vendor due diligence, of course, like as to understand how these third-party vendors protected your data or your organization data, and also, of course, the customer's data. The fourth is to revisit, review, or maybe renegotiate the agreements, the IT service agreement with the data service provider, with IT service providers. Of course, like within this third-party service agreement, there should be the data processing agreement. In some jurisdiction, there are also the requirements under the data protection law to have in place the data processing agreement between the data controller and data processors. So this should be also attached to the service agreement. And also, the organization should also revisit the technical parts, especially the service level or the SLA, service level agreement, whether the obligations of the vendor covered all the new normal of the company's remote working policy, whether the service hours still reasonable, what are the response time, workaround, and does it cover all the connected device that the company will newly use for the employees. Lastly, the company should have the right to suspend or maybe terminate the agreement if there's a lack of the security by the side of the third-party vendors.
Great. I might just cut you off there just so that we can give Joe Fan. Joe Fan, I'm just conscious we're getting a little bit behind time. So maybe if you've got maybe one mitigation that you wanted to share before we move on to the last topic.
Yes, I think I just shared really short that I think another important thing is data transfer issue. So the remote service maybe means that the data will be saved, in different jurisdictions. So it might trigger the cross-border data concern. So I think it's important. And for some industry like the bank and the company providing the financial and medical services, outsourcing also is controlled by is regulated by the authority. So does this kind of change needs approval from authority again, and does the company need to do the risk assessment again? And if the government requests to audit, how the government will do it, I think is also the issues need to be considered.
Great, thank you. I think, yes, that thinking through government audit powers is always can always be a tricky issue, particularly when we're looking across borders. All right, so now we're going to change the scene slightly for our last session. So what we're going to do now is just talk about some of the security and privacy risks that are arising through these rapidly changing business models we're seeing. Now, with some businesses, as they're looking to adapt and stay in business, dealing with COVID-19, it's meant that they needed to change how their businesses operate. And so that might have meant increased use of technology by a business, such as maybe they've been establishing a greater online presence. That's how we all need to shop these days. Also seeing businesses moving into new markets. That might be be a B2B business, moving more into dealing with things on a B2C, a consumer basis. A further and final thought to share is on this is, well, we're certainly seeing greater use of data by businesses to really crunch statistics to work out, well, how is the best way to get to their markets. So Sarana, what are the sort of factors you think are contributing, and what are some of the risks that we're seeing with these new models?
Yeah. As you earlier mentioned, that there has been the change from the B2B and B2C has increasingly changed their business models that have used more technology, means that they have been also using new business method or system in order to improve their sales and improve their marketing strategies. So there's been an introduction to the subscription model, click to collect, and they have digitized their business a lot. So it means that there has been an intensified online competition, because they have tried to use lots of schemes such as loyalty programs, promotions, digital marketing. So this has created sophisticated use of personal data of the customer. So the company has themselves developed to become a data-heavy organization. Instead of using third parties platforms, the company have come and rethink as to how to be a platform themselves, or develop their own website or mobile application in order to directly communicate with the customer, and also have gained more insights through the data that I have collected through the transactions from the customers. So this has increased the volume of the data. And of course, if the company has implemented new tech, such as using authentication method like facial recognition or other biometric data of the customers. So this has increased the risk level as to the use of personal data as well, because these biometric data are considered sensitive data under data protection law of several jurisdictions. Yeah.
Thanks very much. And I guess we're seeing other risk issues with cybersecurity that we've already touched upon, and consumer law issues as well with people moving into these new areas, all still involving data. I mean, would you agree with that?
Yes. There are also other considerations as well, because the company that was probably the brick and mortar one that has just recently changed and do the digital transformation, there has been also, of course, other legal considerations apart from just the data protection, or not just a security issue, but also some other laws such as computer crimes law, which involves the use of the illegal contents over the computer system as well. There's also been the e-commerce law and direct marketing issue about the direct communication with the customers. Consumer protection is also another aspect that the company should take into consideration. But the most important thing is about how the company is considering using the new types of data, or the new high volume of data to develop their business. So there are quick checklists in order for the company to make sure that they are personal data protection law compliant. Firstly, is to understand the new data flows and the new data types that the companies are using, and also identify what are the legal obligations, and are there any compliance gaps for them, and what are the risks of violation of those laws, especially data protection law, and then implement these schemes in order to close the gaps. For example, if you use sensitive data of the customers, you should obtain consent if it is required under the data protection law, or review the privacy notice whether it covers all the new aspects of the purpose of your use of the personal data of the customers. And also maybe lastly to make sure that if you engage third party, you have conduct due diligence of third parties vendors as well.
Oh yes, a very good point there. We've been talking a lot in this session about privacy, but you can see from Sirana's points just now that often, particularly when we're doing something new, it's not just about the privacy law. Still very central, but we're really seeing this convergence, particularly as businesses do their business transformation projects. That we're really seeing a convergence of different laws coming into play, whether it might be, privacy and consumer law, some of the other more specific e-commerce marketing laws that Sirana spoke about. And we're seeing different regulators go into new areas. So for example, in Australia, we're seeing the competition and consumer regulator start to more go into the realm of privacy. And it is a trend we're seeing around jurisdictions. So we might just conclude our part of the session there. And if I could go on to the next slide, please. And we're going to try and answer a few questions. I know people have been submitting questions, so thank you very much for that. As I touched on at the outset, if you were wanting particularly detail on more jurisdictional specific issues, we've got a range of Baker McKenzie publications, one focusing very much on COVID-19 workplace and privacy issues. We do have, I'm pleased to say, our Global Data Privacy and Security Handbook recently launched for this year. So that's available, and all you've ever wanted to read and more on COVID-19 legal issues, we've got a dedicated website for that. So we've also got a link there. But I might ask all the presenters if you can join with me in doing the Q&A. And I haven't had a chance to read the questions, but Ken, I know you've been monitoring closely. Yeah. Would you mind just kicking us off with, we might see if we can get through one or two questions. I hand over to you, Ken.
Sure. So the first question is for me. It's regarding supplementing the privacy policy. What kind of ways can be done for supplementing privacy policy instead of amending the document? Now, I think the answer to that particular question will depend upon how your privacy policy is actually set up. But assuming it's on the intranet, accessible to your employees, then maybe there's ways of having particular addendums towards the end of the privacy policy added. The question that the company needs to ask is, do you really want to be changing the key wording of your privacy document, or do you want to be treating the arrangements that you put in place to address the temperature checking or the employee surveys in kind of like a more standalone manner? And maybe the standalone manner is perhaps a better idea because this current arrangement hopefully won't go on forever, and eventually you probably want those provisions out of your privacy policy. So having it as either an addendum to your existing privacy policy or maybe a standalone privacy policy that ties back to the main privacy policy may be a different arrangement that you can take as opposed to trying to go into the existing wording and tinkering with that too much. So that's my thoughts on that particular point.
Thanks, Ken. Yeah, I think it has been a challenge for some businesses to work out, well, what needs to be a permanent change to my privacy policy particularly for enhanced workplace monitoring, or what might be just a temporary thing that screening and that we have in place for hopefully a short period of time. Joe Fan, I know we've gotten a few questions more around the sort of employee monitoring type issues. I wonder if you could just pick out one of those questions, or maybe see if you can combine a few of the issues together and comment on that. Thank you.
Yeah, sure. I just giving the interest of time. Maybe I pick the second and first and quickly just answer it. The second is if employees have to use their own devices for work-related activities, what should we state down in the policies? And also if want to use to conduct investigations, how to do it. So for the personal device, I think it's important. I mean, first, of course, I mean, to make sure that the device also have certain security. So like the equipment and also the version, so is a compliance with the security requirement of the company, and also the employees need to keep their password regularly updated. So to include these security requirements, and also request that the employees to keep the information confidential and separate from their personal information. So, and I think it's also important for the companies to inform in the policy that how what kind of data the company might collect from this personal device, and also maybe the company have the right to audit. So for some employees who might under the investigation, so the company then can rely on these policy to do the investigation and also to collect the data from the personal device. And the fourth one is, what about a private developed app that's installed on the company devices that are to be used by the employees only in the company facility? I think it maybe is related to the contact tracing app. So I think it still depends on the purpose of why the company would encourage the employees to use the contact tracing app. So of course, I mean, if the use, I mean, if the purpose is okay, and it's also, I mean, is a legitimate, and also this use of the contact tracing app is proportionate, I mean, to this goal, then I think the company might have a good argument to request, I mean, the employees to install especially in the company devices, and they also only use in the company facilities. And also we think the company phone also give the company have more flexibility, because the employee will have a lower expectation about the privacy, which will give the company have a more legal basis to argue.
Great, thanks, Jeff. And I might stop you there because we are over time. So thank you for the other questions. We will go through them, and we can respond to you on those further questions. So thank you everyone for your participation today, and we hope we provided you with some useful information. Very much like to thank my co-presenters. Thank you very much, and thank you to WBCSC for having us. Now, if you have any additional questions, please feel free to contact us directly. And I'm just going to turn over to Mario for some final words. So thank you.
Thanks, Anne. I'd just like to thank our colleagues at Baker McKenzie for a very interesting session today. Please visit, as well as the tremendous resources on the Baker McKenzie website. There'll be a recording of this session posted on our website, and we have many COVID-19 resources for business. The address is there, and if you have any feedback, please please come back to us at events@wbcsd.org. So good afternoon to everyone. Take care, and please stay safe. Thank you.